Welcome to Employment Law This Week. I'm George Whipple. The PRO Act promises to transform the labor relations landscape, if it moves forward. While the future of the bill is uncertain, Epstein, Becker, Green, Steve Swirsky is here to tell us how this legislation could change operations for employers and how it might become law even without strong support in the Senate.
First, it would make it much easier for a union to become the bargaining representative of a group of employees. Unions would no longer necessarily have to win NLRB elections. Employers could be forced to recognize a union based on a card check. That is something labor has been seeking for many years. The PRO Act would prohibit right-to-work laws. Right now, many states, a majority of the states, have right-to-work laws which say a collective bargaining agreement cannot mandate membership in a union or payment of dues or representation fees as a condition of employment. The PRO Act would also make secondary boycotts lawful. A secondary boycott essentially allows a union that has a dispute with one employer to picket and engage in activities targeting other employers that do business with that employer. And that could impose great hardship on the primary employer and force them to agree to conditions that don't make sense for them. It is envisioned that the Senate is not likely to pass the act in its current form, with certainly without changes in the law and filibuster. So the question that is now being explored is there is another way for the advocates of the PRO Act to bring it into law without Senate action. The literature speaks about the idea of taking at least some of the critical elements of the PRO Act and including them in a budget reconciliation package. The significance of that is budget reconciliation legislation generally is not subject to the requirement of a 60-vote majority to have the Senate consider it. It can be enacted by a simple majority. If the elements of the PRO Act were to be included in a budget reconciliation bill, they could move through and the law or key elements of it could be enacted without the need for 60 votes in the Senate. The confirmation of Jennifer Abruzzo as General Counsel of the board has potentially great significance. The board's General Counsel, apart from having an administrative function, really sets the agency's litigation and enforcement agenda. Ms. Abruzzo was Deputy General Counsel during the Obama administration. She's a career NLRB official. Ms. Abruzzo is likely, as General Counsel, to return to many of the priorities of former General Counsel Dick Griffin, who was the General Counsel during the Obama administration. During that administration, the General Counsel's office made a priority of an expansive interpretation and enforcement of the National Labor Relations Act, seeking to bring greater focus on employee rights under the Act in non-union workplaces. I think we can expect a similar agenda and activity under General Counsel Abruzzo.
Thanks, Steve. Steve will have more on the PRO Act in a webinar on August 5th. Epstein, Becker, Green's Mike Farrell and David McNett, a colleague from EBG affiliate National Health Advisors, will also present. Register using the link provided in the description. Thank you very much for watching, and we'll see you next time.